This meeting of the Judiciary Committee will please come to order. A quorum being present, without objection, the chair is authorized to declare a recess at any time. Pursuant to Committee Rule 2 and House Rule 11, Clause 2, the chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote for the ayes and nays are ordered. Pursuant to notice, I now call up H.R. 1585, the Violence Against Women Reauthorization Act of 2019, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 1585 to reauthorize the Violence Against Women Act of 1994 and for other purposes.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. Today, the committee will consider H.R. 1585, the Violence Against Women Reauthorization Act of 2019. This follows the hearing held last week by the Subcommittee on Crime, Terrorism, and Homeland Security on the need to reauthorize the Violence Against Women Act, which we often refer to as VAWA. At this hearing, it became clear that VAWA needs to be not only reauthorized, but also that its critical programs must be expanded and strengthened. The bill before us today would accomplish both of these important goals. I want to thank the gentlewoman from California, Ms. Bass, the chair of the Crime Subcommittee and the sponsor of this legislation, for her leadership in the effort to reauthorize VAWA. I also want to thank Ms. Jackson Lee for her longstanding and tireless efforts over the years to protect and strengthen the Act. VAWA was signed into law in 1994 to help ensure that women in America are free from violence and free from fear. At the time VAWA was enacted, it was all too common for violent crimes against women to go without appropriate response and to remain unaddressed by the criminal justice system. But through programs implemented under VAWA, Congress began to provide communities in America the assistance they need to combat the crimes of domestic violence, dating violence, sexual assault, and stalking. And these programs and resources are unfortunately still necessary. Every year, approximately 7.9 million women are victims of rape, physical violence, or stalking by an intimate partner, and an average of 3 women are killed every day by a current or former intimate partner. VAWA, which is not gender exclusive, addresses the needs of men and women, children, persons with disabilities, homeless persons, and LGBTQ people, among others. Importantly, H.R. 1585 includes new protections for transgender individuals by making them newly eligible for certain DOJ grants and by ensuring that their gender identity is properly recognized by the Bureau of Prisons. The range of individuals VAWA helps is broad and should be as diverse as our communities around the country. I am pleased that this reauthorization continues our commitment to this principle. VAWA has had and continues to have a positive impact on people who rely on its assistance, whether directly or indirectly. Through grants to state and local governments, the Office on Violence Against Women in the Department of Justice funds the work of thousands of advocates in preventing and addressing domestic violence, dating violence, sexual assault, and stalking, and in assisting and training law enforcement and victim advocates. In addition, grants administered through the Department of Health and Human Services provide funds for shelters, rape prevention and education, programs to address and reduce the sexual abuse of runaway and homeless youth, and programs to educate the community on domestic violence. The reach of the work carried out under VAWA is vast, and we must continue to support it. Because of its importance and its success, VAWA was reauthorized on a bipartisan basis in 2000, in 2005, and in 2013. Unfortunately, not only has VAWA now expired without being reauthorized, but because of the foolish government shutdown, we even had a lapse in appropriations for VAWA earlier this year, which jeopardized funding for domestic violence shelters. It is time for us to act, but it would not be enough to merely extend the dates of authorization for existing VAWA programs, as some have suggested. We must set our goal appropriately higher, and our task now is not just to reauthorize VAWA, but to enhance and expand it to make it more effective. H.R. 1585, the bill before us today, is a significant update to VAWA that will strengthen and enhance the vital services currently provided under the law to victims of domestic violence, dating violence, sexual assault, and stalking. Among the provisions within our jurisdiction that this committee will now consider, the bill reauthorizes the Services Training Officers Prosecutors, or STOP grants, administered by the Department of Justice, and it preserves funding for sexual assault services programs. The bill will also strengthen the non-discrimination provisions of the STOP program, as well as provide for greater protections for survivors during the prosecution of perpetrators. In addition, this legislation expands services for older survivors of abuse and for programs targeting domestic violence, dating violence, sexual assault, stalking, and child abuse enforcement in rural areas. H.R. 1585 also expands protection against gun violence and domestic abuse situations, including provisions that extend current federal gun prohibitions to include individuals who have misdemeanor stalking convictions and dating partners convicted of misdemeanor crimes of domestic violence. Another critical improvement over current law is the expansion of jurisdiction of some tribal authorities over non-Indians who commit certain crimes, such as assaulting a law enforcement or corrections officer, obstruction of justice, sex trafficking, sexual violence, and stalking on tribal lands. The Violence Against Women Reauthorization Act of 2019 is comprehensive and inclusive legislation that I hope will earn bipartisan support in the long tradition of this vital law. It is fitting that the committee's efforts on this important bill take place during Women's History Month as we seek to put an end to domestic violence, dating violence, sexual assault, and stalking once and for all. I now recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman, and thanks for holding the markup of H.R. 1585, the Violence Against Women Reauthorization Act, authored by my friend Congresswoman Bass. I'm sad to say that today is a missed opportunity. I, like the vast majority of my colleagues, believe that Violence Against Women Act should be authorized and have been looking to do that ever since last fall. In fact, I supported a short-term extension of the Violence Against Women's Act through the end of the fiscal year to ensure the law remained authorized while we negotiated how best to improve it in a bicameral, bipartisan way. As you know, Congressman Lesko, who, by the way, has worked tirelessly on this issue from our side, and I appreciate all of her work, introduced a short-term extension and tried to have it added to the funding bill, but the Democrats blocked that extension. The Violence Against Women's Act funds critical programs that protect vulnerable women. The goals of VAWA remain as important today as they were when the bill was first enacted to protect and prevent domestic violence and to serve victims. Unfortunately, rather than working with us to find an agreement on how to move this critical law forward, Democrats have decided to rush to a markup a bill that would actually, in our opinion, endanger women. Even if this bill had a glide path in the Senate that would that wouldn't make sense. But Democrats can't even agree that because the Senate is engaged in its own set of negotiations. It is my sincere hope we can ultimately work together to reauthorize VAWA in a thoughtful, meaningful way that preserves the intent of the law. I cannot, however, support the legislation my colleagues have put forward. It politicizes and weaponizes a program and a law that for years was non-controversial and bipartisan. My goal is to reauthorize VAWA, and I remain ready to do that in the way that protects women and girls and assist law enforcement as they respond to domestic violence, prevent violence, and provide services to the vulnerable. We can find a path forward that doesn't sacrifice the safety of women and girls in this process. And with that, I yield back.
Thank you, Mr. Collins. I now recognize the chair of the Subcommittee on Crime, Terrorism, and Homeland Security, who is also the author of this important legislation, the gentlewoman from California, Ms. Bass, for her opening statement.
Thank you, Mr. Chair. I'm pleased that the committee will mark up H.R. 1585, the Violence Against Women Reauthorization Act of 2019. Last week, on March 7th, the Crime Subcommittee held a hearing on the importance of reauthorizing VAWA. It was on that day in 2013 that President Barack Obama signed our last VAWA into law. That law has since lapsed on September 30th, 2018, and America has asked Congress to respond immediately. As such, my co-sponsor, Mr. Fitzpatrick, and I did just that by introducing this bill, H.R. 1585. I want to acknowledge the tremendous work done by Representative Sheila Jackson Lee on this bill specifically and on this issue in general. This year, we celebrate the 25th anniversary of VAWA, as the first VAWA was signed into law on September 13th, 1994 by President Bill Clinton. Today's markup is a reminder of the urgency of now in reauthorizing this vital legislation, which addresses the needs of all victims and survivors that are looking at Congress to act. H.R. 1585 is a sensible and common sense bipartisan measure that has received a great deal of support from an overwhelming number of advocates that have spent the last 25 years working on these very important issues in their respective fields. H.R. 1585 is a product of thoughtful consideration after listening to victims and survivors, working closely with service providers, visiting shelters, engaging advocates on these issues, and reviewing the startling statistic on domestic violence, dating violence, sexual assault, and stalking in America. This was a collaborative effort supported by a broad coalition of experts and advocates, including law enforcement officers, prosecutors, judges, victim service providers, faith leaders, healthcare professionals, and survivors. Many of them are here today. They have spoken and identified the salient, practical, and non-discriminative issues that plague their communities when servicing victims and survivors of domestic violence, dating violence, sexual assault, harassment, and stalking. While much success have resulted from the passing of VAWA in 94, 2000, 05, and 13, much remain. With each reauthorization, VAWA has been improved in meaningful ways to reflect a growing understanding of how best to meet the varied and changing needs of survivors. VAWA 2019, therefore, is no different in that regard. H.R. 1585 builds upon the improvements of previous VAWAs and closes the gaps identified since implementation in 2013. Times have changed, peoples have changed, and circumstances have as well. H.R. 1585 reflects those changes and recognizes the need to arm service providers with the necessary tools and resources to assist those most in need of victim services. H.R. 1585 provides resources to allow tribes to prosecute wrongdoers that are inflicting mayhem in their communities in alarming numbers and holding perpetrators accountable. This bill protects victims and survivors from harm and death because statistics show that firearms in the hands of those who perpetrate domestic violence, dating violence, sexual assault, and stalking increases the likelihood for tragedy in an already dangerous situation for the victim. Domestic violence claims at least 2,000 lives each year. An astounding 17,000 victims disclose the use or threat of firearms being used against them during abuse. H.R. 1585 invests in prevention by increasing the authorization of the Rape Prevention and Education Program and specifically includes sexual harassment to its authorized use. It adds sexual harassment to the allowable uses of the workplace's response to domestic and sexual violence. A national resource center, which provides tools, resources, and training to private employers and federal agencies. H.R. 1585 removes barriers and enforces housing rights for survivors and victims and creates a position at HUD specifically tasked with this work. It increases survivors' options to maintain housing and strengthens the emergency transfer protections in federal housing programs. As we celebrate Women's History Month, we are given an opportunity to send a message to perpetrators of these abhorrent crimes and let women, men, and children know that we stand with them. As Shirley Chisholm once said, you don't make progress by standing on the sidelines, whimpering and complaining. You make progress by implementing ideas. And H.R. 1585 is a sound, practical, and smart idea we need to implement. H.R. 1585 is fair, and I look forward to moving it through this committee. I yield back the balance of my time.
Yeah, listen carefully.
Thank you, Ms. Bass. I now recognize the ranking member of the Crime Subcommittee, the gentleman from Texas, Mr. Ratcliffe, for his opening statement.
Thank you, Chairman Nadler, Ranking Member Collins, for the opportunity to discuss and mark up this piece of legislation to move forward with the important conversation about the Violence Against Women Act and how to best serve and protect survivors and victims of domestic violence around the country. Last week, the Crime Subcommittee had the chance to examine VAWA and hear from 4 different witnesses with varied backgrounds. And our job was to listen and to learn from different perspectives at that hearing and at markups like this one, whether it's from witnesses or from fellow members. And it is normal and to be expected to hear opinions that are different from one's own in Congress. It is not appropriate, however, to shout down those with whom we disagree. Yet, in the span of 1 week, Democrats have introduced a Violence Against Women Act reauthorization that is not designed to prosecute and hold accountable abusers, one that is not designed to further the mitigation, the reduction, or the prevention of domestic violence against women. Instead, this bill is a Democratic wish list of campaign promises. It is not a good faith effort to pass a bipartisan and non-controversial reauthorization. It is instead discrimination against faith-based providers and religious organizations, which serve survivors of domestic violence. It is instead an expansion of VAWA protection beyond women and girls to include men. And I can tell you what is not in this bill, what is missing from this bill. This bill clearly and tragically reduces the ability of prosecutors and judges to hold domestic abusers accountable. Providing VAWA grant dollars for the development and implementation of a, quote, alternative justice response, end quote, is a foolish and misguided proposal that will actually harm survivors and victims of domestic violence. Because just what is an alternate justice response? Well, it is a process that involves the abusers and those they have harmed, the victims, sitting in a room and hoping that the abuser will take responsibility for his actions. And to what end? Because none of the information used during these sessions can be used for any law enforcement purposes without the express permission of all participants, including the abuser. So to be clear, what this means is that when a victim, traumatized after being battered again and again, feels this alternative justice response is the best approach for a variety of reasons: to keep a roof over her head, to keep her children safe, to find a safe harbor free from violence and abuse, and engages in this process. And if by chance the process results in her abuser admitting to abusing her, to harming her, to despising her or her children, then what? This bill clearly states that, quote, information disclosed during such process may not be used for any other law enforcement purpose, including impeachment or prosecution, end quote. As a federal prosecutor, I see this alternative justice response approach for what it is: a mockery of survivors and victims of domestic violence and a get-out-of-jail-free card for abusers. As a nation, we should be vigilant in putting abusers behind bars and ensuring that women and children are kept safe. As a member of this Judiciary Committee, I wonder what kind of message this bill actually sends. There are some things that are more important than politics, and protecting women who need protection from violence should not and cannot be a partisan issue subject to the whims of special interest groups. But I fear this bill is more of the same from the majority. Instead of a partisan bill, we should strive to work on a bipartisan and bicameral basis to reauthorize the Violence Against Women Act. We should offer a bill that truly serves women, that speaks for all of the women who have survived abuse and violence, and speaks also for those victims who were not so fortunate. I yield back.
Thank you, Mr. Ratcliffe. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of the substitute to H.R. 1585, offered by Mr. Nadler.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. I offer this amendment in the nature of a substitute to H.R. 1585 in order to make two minor changes to the bill. Specifically, this amendment first addresses an oversight in drafting and changes the heading for Section 102 of the bill to reflect the name of the subchapter in Title 34 in current law that it is amending. The heading will now be, quote, grants to improve the criminal justice response, unquote, which more closely reflects the title of the relevant subchapter and Section 102's broad goal of improving the criminal justice system. Secondly, this amendment removes from Section 104 of the bill duplicative text concerning the recovery and storage of certain firearms, which is also included more appropriately in Section 102 of the bill. These changes do not alter the policies advanced by the bill or scale back its reforms in any way. Therefore, I ask that my colleagues support this amendment in the nature of a substitute to reauthorize and enhance the Violence Against Women Act. I yield back the balance of my time. I will now recognize the ranking member of the full committee, Mr. Collins, for any comments he may have on the amendment in the nature of a substitute.
Thank you, Mr. Chairman. I oppose this amendment in the nature of a substitute. Unfortunately, this amendment continues with many of the same concerns that I have with the underlying bill, and I think we're so well laid out by the ranking member of the subcommittee just a moment ago. I believe this legislation should serve the needs of victims and work to prevent violence, and it should be focused on women and girls who should be protected in due process. and should provide sensible tools for law enforcement. Unfortunately, this amendment does not do that, and it does not solve those concerns, so I will oppose it. Yield back.
I thank the gentleman. Are there any amendments to the amendment in the nature of a substitute? The gentleman from Wisconsin.
Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1585, offered by Mr. Sensenbrenner of Wisconsin.
Mr. Chairman, I ask unanimous consent the amendment be considered as read.
Without objection, does someone reserve a point of order? Okay. Without objection.
Mr. Chairman, combating domestic violence is a shared goal for members of this committee, and VAWA has traditionally enjoyed bipartisan support. As a former chairman, I authorized reauthorizations and worked to strengthen VAWA programs. However, we are straying further and further from the bill's original intent. In 2013, I ended up voting against the reauthorization because I found it to be constitutionally problematic. For the first time, a provision in the statute, Section 904, extended the criminal jurisdiction of the tribal courts to people who are not members of an Indian tribe and who are accused of domestic violence that allegedly occurred on tribal territory. Tribal courts do not necessarily adhere to the same constitutional provisions that protect the rights of all defendants in federal and state courts. This sets us down the road to a dangerous path. In other words, some tribal courts say that if you are tried before a tribal court, the protections of the U.S. Constitution, of which there are many, particularly in the 4th, 5th, and 14th Amendments, do not apply. They apply for someone who is accused of the same type of crime, either in a federal or a state court. This committee has not looked at this question, and in effect, the 2013 reauthorization ended up taking away the constitutional rights of someone who happens to cross a reservation line and ends up being accused of domestic violence. What this amendment does is to strip the special domestic violence criminal jurisdiction for Indian tribes provision. Congress has a right to be concerned about spousal abuse, and I think every member of this committee is concerned about spousal abuse, and our voting records and our public and private statements have indicated it. Under other forms of domestic violence on Indian reservations, this issue should be addressed in a constitutionally sound manner. I have been on this committee for 40 years. We have never had a hearing on whether we should take away the constitutional rights of non-Indians who end up being charged in tribal courts. That is why this amendment should be adopted. And I think that those who are in support of the amendment should be allowed to talk about it, and those who are in support of continuing the current provision in law, should have more than the debate on an amendment on an important reauthorization bill under the 5-minute rule. I yield the gentleman from Georgia.
Thank you to my good friend. And I agree with this amendment. I support this amendment. And again, it goes to the process issue here and also taking into account some of the concerns that we've had. This is one that needs to be, I think, approved. It still does not overall make this bill any more palatable, but it makes it at least be more consistent with tribal structure and also law, and I would support that. And I yield back to the gentleman from Wisconsin.
I yield back.
I thank the gentleman. I recognize myself in opposition to this amendment. I oppose this amendment and urge my colleagues to do the same. The 2013 VAWA reauthorization included a provision, and therefore it's included in current law, included a provision that reaffirmed the inherent sovereign authority of Indian tribal governments to exercise criminal jurisdiction over certain non-Indians. The provision was limited to crimes of domestic violence, dating violence, and criminal violations of protection orders. By exercising this jurisdiction, tribal communities have increased safety and justice for some victims. There are no constitutional concerns with this provision. This amendment seeks to do away with all of this that we've had operating in the law since 2013. It's a salutary provision of the law. It should not be abolished, and therefore I oppose the amendment. I yield back. Are there any further, is there any further discussion of this amendment? If not, we'll call the roll. The question is on the amendment. All in favor, say aye.
Aye.
Opposed, nay. The nays have it.
Roll call, please.
Roll call is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass? Ms. Bass votes no. Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Swalwell? Mr. Liu? Mr. Raskin? Ms. Jayapal? Ms. Demings? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia? Ms. Garcia votes no. Mr. Neguse? Ms. McBath? Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. Mucarsel-Powell?
No.
Ms. Mucarsel-Powell votes no. Ms. Escobar? Mr. Collins?
Aye.
Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Shabbat? Mr. Gomer? Mr. Jordan? Mr. Buck? Aye. Mr. Buck votes aye. Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Aye. Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Mr. Reschenthaler? Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stubbe? Mr. Stubbe votes aye.
Does any other member wish to vote? Ms. Lofgren?
No.
Ms. Lofgren votes no.
Mr. Cohen?
Mr. Cohen votes no.
Ms. Escobar of Texas?
Ms. Escobar votes no.
Mr. Jordan?
Mr. Jordan votes aye.
Mr. Cicilline?
Mr. Cicilline votes no.
Mr. Liu?
Mr. Liu votes no.
Does any other member of the committee wish to vote who hasn't voted? The clerk will report the result. The clerk will suspend. Do you remember Mr. Biggs?
Mr. Biggs votes aye.
Who? Maybe one moment. What happened? Ms. Jayapal?
Ms. Jayapal votes no.
Ms. McBath?
Ms. McBath votes no.
Anybody else? The clerk will report. Okay.
Mr. Chairman, the vote is 16 noes, 9 ayes.
The amendment is not agreed to. Is anyone, for what purpose does the gentlelady from Texas seek recognition? The clerk will report the amendment.
Mr. Chairman, I reserve on this. Thank you.
Gentleman reserves a point of order. Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1585, offered by Ms. Jackson Lee of Texas.
The gentlelady is reported, Without objection, the amendment is considered as read. The gentlelady is recognized to explain her amendment.
I thank the chairman very much. Let me take note of one of our colleagues, not on the committee, from California, who has diligently reviewed this matter over the years and introduced legislation, even in the last Congress, to deal with the issue of the violence against Indian women. This amendment is a simple amendment, and it responds to the question of getting information. It is a reporting requirement that the Attorney General and the Secretary of the Interior shall jointly prepare and submit a report to Congress, including known statistics on missing and murdered Indian women in the United States, including statistics relating to incidents of sexual abuse or sexual assault suffered by the victims, and recommendations regarding how to improve data collection on missing and murdered Indian women. And as well, the straightforward amendment would simply add language that reinforces that what we have been discussing, that every woman deserves the same protections under VAWA. On some reservations, Native women face murder rates that are more than 10 times the national average. More than 80% of American Indian and Alaska Native women have experienced violence in their lifetime. Most of these cases are crimes of sexual violence committed by non-Indian perpetrators. Finally, to my colleagues, these findings show that the Special Domestic Violence Criminal Jurisdiction successfully protects Native victims, help victims find justice, improves the tribal court systems, effectively uphold due process for non-defendants. If the provisions of this bill, underlying bill, is implemented, my amendment would ensure that the legislative intent is clear around these protections, that we learn to improve how to collect the data, and that we show that the incidences, because of the work that we're doing, finally diminishes. And I share with my colleague this pie: Native American women raped who experience other physical abuse, 96%. 96%. And I would hope that we would want to get the facts. When we get the facts, I know this Congress acts in a bipartisan and deliberative way. I ask my colleagues to support the Jackson-Lee amendment.
The gentlelady yield to me?
I'd be happy to yield.
I will simply say that I support the amendment. It simply establishes a reporting requirement to help us deal with the large number of Indian women who are assaulted and sometimes murdered, so I support the amendment. I yield back.
I thank the gentleman, and I will yield back. I do want to take note of the women who organized around this, which is the gentlelady from California, Ms. Torres. So I thank you very much, and I will yield back and ask my colleagues to support the amendment.
And does the gentleman from Colorado insist on his point of order?
No, I withdraw my point of order.
Thank you very much. Does anyone else wish to be heard on the amendment?
Mr. Chairman, I move to strike the last word.
The gentleman is recognized.
I just want to speak in support of this, and I thank the gentlelady from Texas for bringing this amendment. This is in Colorado, and as a member of the U.S. Attorney's Office in Colorado, we had jurisdiction over crimes on reservations, and I can speak firsthand to the fact that there is a very large population that is ignored and underserved, and I thank my friend from Texas for bringing this amendment.
Thank the gentleman.
Is there anyone else who wishes to be recognized on this amendment? If not,
Mr. Jayapal.
Ms. Jayapal, yes.
Thank you, Mr. Chairman. I thank my colleague from Texas for bringing this very important amendment. And Mr. Chairman, I ask unanimous consent to insert into the record a new report from Seattle's Urban Indian Health Institute. It actually documented that Seattle has the most number of missing and murdered Native American women in the country, of major cities in the country. And so this is a critical amendment for us. Again, I thank my colleague from Texas for offering it, and I support the amendment.
And you yield back. Does any other member wish to be heard on the amendment? If not, the question occurs on the amendment. All those in favor will signify by saying aye. Aye. Those opposed, no. The ayes have it, and the amendment is agreed to. Are there any other amendments? The gentleman is recognized. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1585, offered by Mr. Buck of Colorado.
Mr. Chairman, I reserve a point of order.
Without objection, the amendment will be considered as read. The gentlelady from Texas.
Reserves a point of order.
Gentlelady from Texas reserves a point of order. The amendment is considered as read. The gentleman from Colorado is recognized to explain his amendment.
I thank the chairman. As a former federal prosecutor, I have seen firsthand the issue of domestic violence and the other crimes addressed in this bill. I agree Congress should focus on ways to address these issues. I do have to say, however, that I think the approach to this bill is unnecessarily partisan. In the past, VAWA enjoyed the broad support of members of both parties. Unfortunately, that cannot be said with this year's VAWA reauthorization bill. One area that is unnecessarily partisan involves findings related to the connection between guns and female deaths in domestic situations. I would urge the majority to review your findings. I think you have mischaracterized what certain studies have found. In fact, this bill also cherry-picks data. In one such case, your bill uses data to support your political objectives while you fail to mention the most significant finding in one of the studies you cite. I want to bring the conclusion of this study to the attention of the committee. To quote the study, an abuser's lack of employment was the only demographic factor that significantly predicted femicide risks after we controlled for a comprehensive list of more proximate risk factors. This committee should take note how important job creation is for curbing domestic violence. Thankfully, the actions of the current administration and its focus on job creation is working. This will have an important impact in reducing domestic violence. Second, the tax modification bill passed last Congress is helping to create jobs, and this too will reduce female deaths due to domestic violence, according to the study the Democrats cite in their bill. In terms of my amendment, it will do two things. First, it adds an additional conclusion to the findings in the bill from one of the key studies the majority has cited in their bill. This study concluded that after accounting for variables, when a woman who has been a victim of domestic violence has sole access to a firearm, she is safer. The reason for this is obvious. She is able to defend herself. Second, consistent with the important scientific data, this amendment would allow the Attorney General to provide VAWA grant money to organizations that conduct firearms training courses for victims of domestic violence. Proper training will empower victims, giving them a sense of security. It will allow them to protect themselves, curbing future instances of domestic violence. The studies Ms. Bass has used in her bill support this common sense approach, and I urge the committee to adopt my amendment. And I yield back.
Thank you. Does the gentleman yield back? Does the gentlelady insist on a point of order?
I do not insist on my point of order.
Point of order is not insisted upon and is withdrawn. I recognize myself in opposition to the amendment. This amendment is too broad and risks gutting grant resources that are sorely needed to address the VAWA purposes. The grants that are authorized are for the purposes of domestic violence, dating violence, sexual assault, stalking, and other crimes. Firearms training is really beyond the scope and is a different question. And I don't think we ought to use these funds for firearms training. And therefore, I oppose the amendment. And urge my colleagues to do so. Is there any other discussion on the amendment? Hearing none, the question occurs on the amendment. All those in favor will signify by saying aye. Aye. Opposed, no. No. In the opinion of the chair, the noes have it.
Mr. Chairman.
The noes have it, and the amendment is not.
Ask for a roll call vote on that.
Roll call vote has been requested. As your name is called, all those in favor of the amendment will signify by saying aye. All opposed, no. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson-Lee? No. Ms. Jackson-Lee votes no. Mr. Cohen? Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia? Ms. Garcia votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. McCarcel-Powell?
No.
Ms. McCarcel-Powell votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins? Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Shavit? Mr. Shavit votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Mr. Reschenthaler? Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Armstrong votes aye. Mr. Stubbe? Mr. Stubbe votes aye. Ms. Lofgren votes no. Mr. Deutsch votes no. Mr. Jordan votes aye. Mr. Gates votes aye. Ms. Bass votes no. Mr. Reschenthaler votes aye. Mr. Liu votes no. Mr. Chairman, your mic, please.
Are there any other members of the committee who wish to vote who haven't been recorded yet? Not, the clerk will report.
Mr. Chairman, there are 14 ayes and 19 noes.
A majority having voted against the amendment, the amendment is not agreed to. Are there any other amendments?
Mr. Chairman, I have an amendment at the desk.
Who is Mr. Johnson? The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1585, offered by Mr. Johnson of Louisiana.
Mr. Chairman, I reserve a point of order.
The gentlelady from Texas reserves a point of order. The gentleman from Louisiana is recognized to explain his amendment.
Thank you, Mr. Chairman. My amendment would simply require all entities that receive funding authorized through the Violence Against Women Act to certify that none of the funds will be used to perform an abortion. Make no mistake, we believe the reauthorization of the Violence Against Women Act is important, and it's unfortunate that this Congress has turned the law into such a partisan instrument. It's critical, whatever we do, to ensure that women and children are protected from violence, and this is exactly why the best organization should be equipped to provide the best care to those that need it most. That said, unfortunately, the current legislation, as it's written, opens the door to federal funds being channeled to organizations with a long track record of providing abortions. In fact, U.S. Government Accountability Office released a report in 2018 stating that Planned Parenthood received $340,000 over a 2-year period through grants administered under VAWA. The question we must ask ourselves today is, as we seek to provide care, should an organization fraught with cases of sexual abuse cover-up be on the receiving end of these grants? Our hearts break when we hear stories, shocking as they are, like this one, the young daughter of George Savannah in the state of Washington, who in 2014 was found to have taken his daughter 3 different times to a Planned Parenthood clinic, each time for a forced abortion after he impregnated her. Once when she was 14, again at age 15, and again at age 17. What did Planned Parenthood do to prevent such abuse? Not a thing. So again, I ask, does this sound like the type of organization that seriously believes in bringing justice to the abused? Nearly 4,000 innocent lives were lost to abortion in my district in 2016 alone. And since Roe v. Wade, we all know the statistics. Nearly 60 million children have been aborted in the United States, and the statistics on abortion are staggering, and they should not be. In Louisiana, over 770 children are taken each year from what at times is an abusive situation, much like the ones we're discussing today, and they're welcomed into loving arms all across the state through foster care and adoption. That is a statistic we can be proud of and should support. Programs like these provide opportunities to advance the cause of justice for vulnerable women and children. VAWA should never be used as a tool to harm or terminate innocent lives or to promote organizations engaged in the cover-up of sexual abuse cases. I urge my colleagues to support this amendment. I yield back the bill.
Will the gentleman yield, Mr. Johnson, for a
I will
question?
yield. Sure.
Thank you. In the description you just gave, I think you said that this amendment was intended to be sure that no money could be used for an abortion. But, of course, the language of the amendment is much more expansive because, of course, that prohibition already exists under the Hyde Amendment. But your language in this amendment says, no federal funds may be provided, directly or indirectly, to an entity unless the entity certifies that during the period for which such funds are provided, the entity will not perform and will not provide any funds to any other entity that performs an abortion. So in an entity, for example, like Planned Parenthood that has spectacular domestic violence programs, would be prohibited from providing desperately needed services to women who are victims of domestic violence because that agency may, in fact, perform abortion. So it's
With other funds.
That's right. So it seems that, I mean, just to be clear, your description about no federal funds for abortion is actually not what the amendment does. It says we are going to punish any agency that exercises what our Supreme Court has said is a constitutionally protected right to provide in services to terminate a pregnancy by denying them resources to provide this desperately needed domestic violence services. And so I obviously strongly oppose this amendment, but I think we need to be honest with our committee members about what it actually does. If that wasn't your intention, then perhaps you can withdraw the amendment and make another stab at it.
Well,
Let's not make another stab.
reclaim my time. Delighted that you weighed in. It's an astute observation. If we can fine-tune the language, I would certainly welcome your assistance in doing that, to make sure that these funds are not provided for abortion. If Planned Parenthood or any other organization wants to do these worthwhile services of preventing violence against women, we're all for that. One of the concerns we have is that it was announced over the weekend that the Democrat leadership is intending to try to take a strike at the Hyde Amendment. And we were all surprised to hear that. I hope it's just a rumor. I hope I'm wrong. But our intention is to make sure that that prohibition remains in federal law.
Well, if I could just, if you'll yield one more time, I take you at your word that that's your intention. I hope you will agree that's not what the language is. So if that is your intention, I would at least ask you to at least offer an amendment that captures that versus this.
We can change one or two words to fine-tune that language, but I think the intent of the amendment hopefully is something that we should agree to in a bipartisan fashion. The purpose of VAWA is not to fund abortion, obviously, is to protect women and children. Abortion is obviously the opposite of that. It takes the life of an unborn child. So for that reason, I'll modify the language and reintroduce it. Thank you.
Does the gentlelady insist on her point of order?
I insist on my point of order, Mr. Chairman. I insist on my point of order because the amendment adds a new title to the bill. It is outside the scope of the bill. It does not amend any existing part of the bill, and it falls, as I indicated, outside the scope. Therefore, this amendment is non-germane.
Does the
Point of order,
gentleman-
Mr.
does the-
Chairman, I think,
does-
point of order.
There's no point of order right now. Does the gentleman wish to be heard on the point of order?
Let's do it and introduce it.
I'm sorry.
Unless you want to withdraw the amendment altogether.
I believe it is germane. I think it's perfectly consistent with the intent, the spirit of the law, and with the language. And so we will fine-tune the language, and I'll reintroduce it.
So you withdraw the amendment?
I'm going to withdraw it at the moment and reintroduce
The
it.
amendment is withdrawn.
Been withdrawn.
Do not have to rule on the point of order. The amendment is withdrawn. The gentleman may wish to offer another amendment later. That's his privilege. Does anyone else, does any other member have another amendment?
Yes, Mr. Chair.
Who's seeking recognition? Ms. Lesko.
Yes, thank you. Thank you, Mr. Chair. I offer an amendment, and
You have an amendment at the desk?
I do have an amendment.
The
at
clerk will
desk.
report.
Thank you.
Amendment to the amendment in the nature of a substitute, ordered by Ms. Lesko of Arizona.
Thank you. Mr.
Without
Chairman.
objection, the
Chairman,
amendment will be considered
Chairman, I raise a point
as
of order.
read. The gentlelady is recognized to reserve a point of order. The gentlelady from Arizona is recognized to explain her amendment.
Thank you, Mr. Chairman. I appreciate it. As I've said before, I'm a survivor of domestic violence. I also serve on the Advisory Council in Arizona for Domestic Violence Shelter, and I'm co-chairwoman of the Congressional Working Committee on Domestic Violence here in Congress. As you know, I moved on the floor to extend an extension until September 30th of the current Violence Against Women Act so that we could work in a bipartisan fashion to protect women and children. And so my amendment I call the Privacy and Safety for Women Amendment. And I really believe that as the title entails, Violence Against Women Act should be about protecting women. And so, simply put, my amendment says nothing in this act or the amendments made by this act may be construed to compel a victim service provider, as such term is defined in Section 40002 of the Violence Against Women Act of 1994, to place a woman or child into a circumstance in which the woman or child has grounds to fear for a violation of privacy or for his or her safety. I think this is common sense. I think we need to have common sense in this bill to protect women and children. And let me tell you why I feel I need to offer this amendment. Basically, there's several examples, but one example is what we talked about briefly, or actually not briefly, in our last hearing on VAWA. And it's because this VAWA bill that we're putting forth today has the government forcing organizations to take in men in women's shelters. And there is an example in the Downtown Hope Center versus the municipality of Anchorage. And this Downtown Hope Center, who has been helping men and women for years, not only with homelessness but domestic violence, is actually the municipality is suing them and the Downtown Hope Center for allegedly violating a local law by providing a safe shelter only to biological women. And so in their center, because all centers are different. I mean, some centers in Arizona, domestic violence shelter, have separate rooms where men could be next to a woman, but some are congregated. And so in this case, they had at night, the Hope Center serves homeless women, most of whom have suffered rape, physical abuse, and domestic violence, by providing them a safe place to sleep at night. The Hope Center's women's shelter consists of one room with mattresses set 3 to 5 feet apart from one another. So what my amendment does is say, listen, the shelter should be able to protect women and children. And so sometimes if there is a situation where there's a biological man right next to a biological woman, that woman would not feel safe. And that's why I think this amendment is a good amendment, and I encourage my colleagues to vote yes on it. I yield back my time.
The gentlelady yields back. Does the gentlelady insist on a point of order?
Mr. Chairman, I do not insist on my point of order.
The gentlelady does not insist on her point of order. I recognize myself in opposition to the amendment. The amendment's apparent purpose, based on the language in the amendment, appears benign, but I don't know what it means. Nothing in this act may be construed to compel a victim service provider, that's as defined, that's clear, to place a woman or child in a circumstance in which the woman or child has grounds to fear for violation of privacy or for his or her safety. I don't know how a court would interpret that. I don't know that the language is extremely broad. What is it? What is a violation of privacy? What is grounds to fear for violation of privacy or safety? Obviously, common sense has to rule. You wouldn't put someone where there is a problem. But I think this amendment is very vague. service providers from rape crisis centers, shelters, and others who work each and every day to meet the needs of all survivors and reduce sexual assault and domestic violence throughout society I think, can be trusted to try to avoid placing people women or children in circumstances in which they have grounds to fear for violation of privacy or for their safety. Insofar as the amendment, and I heard the explanation from the gentlelady, it's not what the amendment says, but insofar as it is intended to deal with transgender people, I will simply say that service providers from these organizations, rape crisis centers, shelters, and others who work each and every day to meet the needs of all survivors and reduce sexual assault and domestic violence throughout society overwhelmingly agree that the claim that transgender women are a danger to other women in shelters is false. So insofar as this amendment is directed at transgender individuals and their placement, I would oppose it because there is not a threat. But I would oppose it further because we don't know what it means. I mean, it might mean that, it might mean a lot more. The language is extremely vague, and we should not put into the law language that we really don't know what it means. We know what the sponsor says she intends, but language that simply says circumstance in which the woman or child has grounds to fear for violation of privacy or for safety, is that a subjective judgment? Is it an objective judgment? Whose judgment is it? What does it mean? I don't know. And for that reason, I urge the defeat of this amendment. And if it's directed at transgender individuals, insofar as it may be held to be directed there, because it doesn't say that, but insofar as that is the intent, then it's an invalid intent because, as I said, everybody who deals with this knows that there's no particular reason to think that transgender women are a danger to other women in shelters. So I oppose the amendment. I urge my colleagues to oppose. I urge my colleagues to oppose the amendment. Does anyone else?
Mr. Chairman.
Would the gentleman yield his time?
All right, I'll yield. Who requested I yield?
Let's go.
I will yield to the gentlelady.
Thank you, Mr. Chairman. I appreciate the yield of time. I do think it's valid, and I do think that there is a concern if a biological male is put right next to a biological woman. So there's women that are in these shelters, and some of them have been raped, most have been abused, and it is not fair to the woman. If this is called the Violence Against Women Act, it's not fair for the women that the government is forcing these organizations to take in biological males to be sleeping right next to biological women. I don't think that's fair to the woman.
Reclaiming my
Mr.
time,
Chairman.
I think you've made the point. Let me just say that I disagree with you because transgender women are not biological males. They are transgender women, and that's simply a reality. I know there are people who deny that reality, but I think it is a reality. So I'd oppose the amendment on that basis. But again, even if I agreed with you on that, I'd oppose the amendment because the amendment doesn't even say that. The amendment is very vague. I'll yield back the balance of my time. Does anyone else seek recognition? The gentleman from Maryland.
Thank you, Mr. Chairman. Just 2 points here. One is to hear the gentlelady describe the amendment. I think she wants to use the word allow rather than the word compel. That is, she doesn't want to allow a victim service provider to do the things that she considers objectionable or dangerous. So she really wants to override whatever the providers are doing because she hasn't stated any case in which the act has been interpreted to compel anyone to have any particular policy on the matter that's troubling her. So we've got one confusing amendment following another confusing amendment, and in fact, this one's very much in tension with the last one because if it has any meaning, the last one, I mean, it seems that the way that it was corrected by the gentleman from Louisiana, it's just redundant and duplicative of the Hyde Amendment, but the way that it's read, it would actually deny the ability of women to receive abortions when their own health is at stake. And this one says that you can't place a woman in fear for violation of her privacy or for her safety, and that's precisely what the other one would do. So one bad amendment follows another. I just say we reject them both. I yield back to you, Mr. Chairman.
Mr. Chairman.
The gentleman, does anyone else seek recognition?
Mr. Chairman.
Mrs. Cicilline had sought recognition first.
Thank you, Mr. Chairman. I thank the author of the amendment for providing clarification of what the purpose of this amendment is, and it's clearly designed to deny services to transgender individuals. It's important to remember, we heard from a witness who made the same claim that transgender people just don't exist. There are only men and women, period, as if you can eviscerate the existence of transgender women or transgender men. The reality is transgender, gender nonconforming, and gender fluid people are disproportionately survivors of violence. They deserve access to services consistent with their needs, and it's important that we recognize that according to the U.S. Transgender Survey, which surveyed nearly 28,000 transgender adults, almost half of those individuals have been sexually assaulted in their lifetime. According to the latest FBI statistics, more than 17% of all hate crimes reported in 2017 were based on the victim's sexual orientation or gender identity. And the Human Rights Campaign found that at least 128 transgender individuals have been killed since 2013. There is no evidence to suggest that placing transgender women into shelters poses any danger to anybody. In fact, all it does is ensure that transgender people are safe. Transgender people are disproportionately survivors of sexual assault, and they deserve access to services consistent with their gender identity. Domestic violence providers and law enforcement agree that transgender women being in the same space as other women does not make them less safe. Laws that prohibit discrimination based on gender identity have been in place for years, including specifically for VAWA programs, and there is no evidence that this has caused any problems. And there are hundreds of organizations that voice their strong support for these protections in the National Consensus Statement of Anti-Sexual Assault and Domestic Violence Organizations in support of full and equal access for the transgender community. Law enforcement leaders also agree that protections like these are not associated with any increase in safety-related instances, and witnesses from the National Coalition Against Domestic Violence and the National Council of Juvenile and Family Court Judges voiced their support in this hearing last week. So this is about ensuring that everyone has access to the protection and services they need. This notion that we can somehow deny a whole category of individuals, that is transgender women, the same services because of some conjured up notion in someone's head that it's a danger would be a grave mistake. I find it particularly painful and ironic that on the day that we will introduce the Equality Act, that will once and for all end discrimination against members of the LGBT community in housing, employment, public accommodations, jury service, credit, education, and federal funding, to once and for all say citizens are fully equal in the eyes of the law in this country. On the very day we'll do that with the support of virtually the entire Democratic caucus and several of our Republican colleagues in a bipartisan way, that this amendment is put forward in direct contradiction to that, to those values and to our aspirations, and I urge my colleagues to vote no on this amendment.
Chairman.
The gentleman from Arizona? No, California, I'm sorry.
Colorado.
Colorado.
It's one of those western states. I move to strike the last word. I move to strike the last word.
The gentleman is recognized.
Thank you. First of all, Mr. Cicilline, nowhere in this amendment does it say the word transgender. So I take the gentlelady from Arizona at her word that this is not aimed at transgender. But I would like to ask
The gentleman, that's exactly what she said. She explained it as biological women, which is distinguishing transgender women from women that she believes were born or biologically women. So that was what she provided in her explanation. I didn't make that up. That's her argument in support of this amendment, which has innocuous language, but is clearly designed to permit discrimination against transgender women.
Reclaiming my time, I'd like to ask the proponent of the bill, the sponsor of the bill, a question, if I may. Ms. Bass, may I ask you a question?
Maybe.
It's my understanding.
You can yield time to Ms. Bass if you want.
I will, let me ask the question, then if, actually anybody can answer, but it's my understanding that the intention of this bill is to expand coverage for domestic violence to men also. Is that fair? Part of the intention of this bill.
The Violence Against Women's Act, but, you know, again, let me go back to what my colleague said. A transgender woman is not a man.
That's not my point at all. I'm not dealing with that.
No, but I do think that's the
But I think that
Congresswoman's point.
But my point is that I represent a very rural area of the country, and I want to make sure that there is an understanding that we're not trying to place men in women's shelters. In my jurisdiction, we would rent, or the police department would get a hotel room if a man was a victim of domestic violence, for
Yes.
example. And that's the intention of this
Yes.
bill, is not to have some sort of co-ed or force.
No, no, and I mean, of all of the hundreds of shelters around the country, I have never heard of such a thing, which is why I said where I think the gentlelady is coming from is talking about transgender women.
Okay. And I want to clarify that, that's all. I appreciate it. I yield back.
No problem.
Gentleman,
I'm sorry, I
The
want
gentleman-
Mr. Chairman, if I may, I want to yield to the gentlelady from Arizona.
gentleman yields to the gentlelady from Arizona.
Thank you, sir. Actually, there's been several statements as there's no evidence that there are any problems. Actually, there is evidence. Right now, there's a civil suit going on in Fresno, California. Downtown Fresno's Pavarallo House is being sued in federal court by 9 women who say they were subject to sexual harassment by a transgender individual and that staff failed to take action to stop it. One of the reasons came up with showering, that they were allowing the transgender individual who was preoperative transgender, meaning that she was a male, biological male, to shower with the other women. And so I would like to offer this into the record that there is evidence that there is a problem. Now, nothing in this, my amendment, prevents any organization from taking in anyone. But what this bill does is it forces, according to the Obama Department of Justice, actually they had an opinion, and I'm going to read it. Obama's Department of Justice said that VAWA grantees should ensure that services don't isolate, segregate victims based on gender identity. Grantees can't make a services determination for a beneficiary based on the complaints of other beneficiaries, meaning that you're prioritizing the transgender woman who is a biological male over the rights of the women. And so all I'm saying is, in a case-by-case basis, in this amendment, if there is a privacy issue or a safety issue of any victim, no matter what their sex is, the organization should not be forced by the government to do what's in this law. And thank you, I yield back.
The gentlelady from...
Chairman.
Chairman, my time has not expired yet.
Gentlelady,
He's yielding to Mexico.
Mr. Buck is yielding to...
I'm yielding to Mr. Collins.
Gentleman is recognized.
Thank you, and I won't take long. I just support the gentlelady's amendment. I think the evidence has been put in, and this is something, again, as we work through this bill to find a solution, this is one that I believe it needs to be supported, and I just wanted to make sure that that was on the record. Now yield back to the gentleman from Colorado.
Chairman.
Does the gentleman from Colorado yield back?
I yield back.
Thank you. The gentlelady from Pennsylvania, Ms. Scanlon.
Thank you. I just wanted to speak on behalf of transgender women, particularly transgender women of color who suffer from tragically high levels of violence. In 1 week in September last year, 3 Black transgender women were murdered, including Shantae Tucker from Philadelphia. And this is amid an uptick in violence against transgender women of color. I don't think there's anything in the act or the act as amended that we're considering that would require violations of poverty. And I would concur with
Privacy.
Mr. Nadler that the amendment is just not tightly drawn enough to address the situation that my colleague from Arizona is concerned about, apparently. And I would also ask to submit into the record this letter from the National Task Force to End Sexual and Domestic Violence, supporting non-discrimination protections for transgender people.
Without objection,
Mr. Chairman.
And I would yield back.
gentlelady from Texas.
First of all, I want to say thank you, Mr. Chairman, to the gentlelady from Arizona. We meticulously crafted this bill to embrace and protect. We crafted it in the backdrop of constitutional protections that deal with privacy. We also crafted it in the backdrop of ensuring that people who had experienced violence would find a place of refuge. When Judge Gonzalez testified here last week, she made it very clear that persons who came before her, transgender and otherwise, were not in any way attempting to fraudulently represent who they were and that they needed protection. We want to make sure that that protection continues and occurs. And the court case that you're speaking of will be judged accordingly. But it is well known that federal courts have ruled again and again that it is not a violation of privacy simply to have to share a space with a transgender person. This act does not condone bad acts. It provides a protection for those who need refuge, comfort, a bed. And I would hope that the gentlelady would understand or see that we will not want to exclude anyone that has suffered abuse. And I would indicate to the gentlelady that I think the protections that she is looking for is within the four corners of this bill, and the opportunity for the individual agencies to make their case if there is danger can be made locally with local law enforcement. And by the way, we provide $291 million to enhance local law enforcement for any necessities of protecting people who have experienced violence. And I think that that would certainly be the case in your particular case that you speak of. And unfortunately, although I understand your intent, I'd have to oppose the amendment.
Would the gentlelady yield?
I'd be happy to yield.
I would just like to note, on the policy issues, I don't disagree with the comments that have been made, but we're the Judiciary Committee, and it falls to us to craft legislation that is certain and precise so that, judges can know what it means. And this is so loosely crafted, it falls short of what we would need as a standard of excellence in terms of legislation. So whatever one thinks about the underlying issue, and I agree with the comments made to protect transgender individuals, this could never be accepted because of its how loosely it is crafted, and I thank the gentlelady for yielding.
Thank you for reclaiming my time. The gentlelady from California has made a very precise statement on, I think, the general impression that we got when we saw the amendment, the difficulty of understanding its place. And I just conclude by saying, not only would it be the difficulty of the courts interpreting it, it would be the difficulty of the beneficiaries of the Violence Against Women Act to interpret what that provision would mean and who in the administration, meaning what agency would be enforcing this aspect of the language or of the provision. So I thank the gentlelady from Arizona for her concern, but I think the weight of the law, the weight of the issues of violence against all people that would experience it, and the desire of the bill as we have it to protect all who have been experiencing that is would cause me to oppose the amendment, and I yield back.
Mr. Chairman. Mr. Chairman.
The gentlelady has yielded back. For what purpose does the gentleman seek recognition?
Move strike last word.
Gentleman is recognized.
Thank you. I just want to comment on the gentlelady from California, and I think it was said of her preciseness. I think the interesting issue here is if we use the standard of preciseness and non-ambiguity, then H.R. 1 would have never came to the floor. And then we'd have had some other issues with this thing. So I appreciate the gentlelady's concern. I think the amendment, though, is good. And to the way it is written, again, I just want to point out that we've had disagreements on the preciseness, not only of H.R. 1, H.R. 8, and others as we've gone through. So I think this one actually says what she wants it to say. But when you actually have other language written in the statute that we've already passed that is completely imprecise and also would lead to a result, I just wanted to point that out as we go forward. I yield back.
Representative
I thank the gentleman for yielding back. I simply want to say I hope we can get to a vote on the amendment without debating H.R. 1 or H.R. 8. Is there any further discussion on the amendment?
Mr. Chairman,
Who seeks recognition?
I do move to strike the last word.
Gentleman is recognized.
I yield to the gentlelady from Arizona.
Thank you, Mr. Chairman and members. I appreciate the comments from the gentlewoman from California, Representative Bass. And I want to point out that I really wanted this to be a bipartisan bill, and I reached out to your office, I reached out to other Democrat offices to try to craft language that could be bipartisan, because I too share the goal that we need to protect individuals that are abused. In no way does my amendment discriminate against anyone, but what it does do is say that the government shouldn't be forcing organizations to take in biological males if a woman feels in some way her safety or privacy is threatened. As to the vagueness of the language, would the gentlewoman from California be amenable to working with me if you share my goal in protecting women, to design language that you view as not as vague? My goal and your goal are the same, and that is to protect women. But I do have a serious concern, and I don't think we can just dismiss it, that if a biological male has to sleep right next to a biological woman, there may be a concern. There may not, but there may be. And under the Obama administration's Department of Justice interpretation, the woman in that case, even if she complained, the other person's, the biological male's priorities, it's prioritized over the woman. And if this is about Violence Against Women Act, I really think we need to protect women. And so my question is, was the gentlelady from California, Representative Bass, be amenable to working together if you think this language is too vague on less vague language? And I yield back my time.
The gentlelady yields back.
Mr. Chair?
The gentlelady, for what purpose is gentlelady from,
Well, let me just say to my colleague on the other side of the aisle that I would be more than happy to work with you so that we could come up with language that we could both agree with. And I think in the course of us working together, I think it would be really helpful if we work together to understand the transgender community, to understand what transgender is, to understand what it is to go through the process. Years before coming here, I worked in a clinic that took care of transgender individuals through each stage of the process. And so maybe we could visit shelters together. Maybe we could really get at the bottom of whether or not this is a serious problem or whether or not one incident happened. So I would be happy to work with my colleague, and we will both learn together. Thank you.
the question occurs on the amendment. All in favor, say aye. Aye. Opposed, no? No. The noes have it.
I call for a roll call vote.
The noes have it. The amendment is not agreed to. A roll call vote is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee?
No.
Ms. Jackson-Lee votes no. Mr. Cohen? Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Deutsch? Ms. Bass? Ms. Bass votes no. Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Mr. Liu votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? Ms. Demings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia? Ms. Garcia votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Mr. Stanton? No. Mr. Stanton votes no. Ms. Steen?
No.
Ms. Steen votes no. Ms. McCarcel-Powell? Ms. McCarcel-Powell votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins? Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Shavit? Mr. Shavit votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Buck? Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Johnson? Mr. Johnson votes aye. Mr. Biggs? Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Reschenthaler votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Armstrong votes aye. Mr. Stube? Mr. Stube votes aye. Mr. Deutsch votes no.
Mr. Johnson of Georgia.
Mr. Johnson of Georgia votes no.
Does anyone else wish to vote who hasn't voted? The clerk will report.
Mr. Chairman, there are 11 ayes and 22 noes.
The amendment is not agreed to. Are there any further amendments?
Mr. Chairman.
The gentleman from Texas is recognized.
Chairman, I have an amendment at the desk.
The clerk will report.
Amendment to the amendment in the nature of a substitute to H.R. 1585, offered by Mr. Gomert of Texas.
Without objection, the amendment will be considered as read. The gentleman from Texas is recognized.
Thank you, Mr. Chairman. This amendment to the amendment in the nature of a substitute would ensure that girls and women who are victims of female genital mutilation or female circumcision are eligible to receive assistance through the Violence Against Women Act programs. This amendment's badly needed because female genital mutilation and female circumcision is a very real and horrific procedure performed on countless girls and women around the world, including right here in the United States. Unfortunately, the Office of Violence Against Women does not have the authority to target funding to these very victims and assist them with their problems. If a girl or a woman seeks assistance from a Violence Against Women Act grantee because she's a victim of female genital mutilation or threatened with mutilation, right now, and under this amendment in the nature of the substitute, she will be ineligible for any of the services under this bill. The way the law stands now, a victim of female genital mutilation must also be a victim of some additional qualifying crime just to get the help that we have put in the Violence Against Women Act, including domestic violence and sexual assault. Female genital mutilation is already a heinous crime, and a victim should not be burdened with having to prove additional abuses in order to just receive the help and care that she needs from a grantee under this bill. The amendment is very similar to the Empower Our Girls Act introduced by Representative Scott Perry of Pennsylvania, and I thank him for his efforts. But I urge my colleagues to help protect women and girls by supporting this amendment. This is something they really need help with, and I hope that we can embrace this within the Violence Against Women Act. I'll yield to Mr. Collins.
I thank the gentleman from Texas. I think this is an excellent amendment. I think the way it's been worded, I think there's probably going to be agreement on the side to work to get this into the bill. And I just want to say I support what you're doing here. I appreciate the intent in which it's offered, and I think this is something that we can work with. With that, I yield back to the gentleman.
Would the gentleman yield?
No,
I will yield to my friend from Texas.
Let me thank the gentleman from Texas. Over the years, I've offered legislation dealing with female mutilation, and I think this is constructive, and it is no doubt that more of it happens than not, and in this country. And therefore, it looks and appears constructive for helping those who have heretofore had to be silenced. And so I thank the gentleman. I yield back to the gentleman.
And I recognize myself on the amendment.
Well, I still had some time left. She yielded back to me. And I just wanted to thank her for her efforts over the year. I recall those efforts and applaud them and appreciate the gentlelady's comments. I yield.
Would the gentleman yield?
I yield to my friend from California.
I think whether or not, this is 3 pages and we don't have the underlying bill, so I think we want to work and make sure that we agree in the drafting of it, but I completely agree with what you're trying to do. And I think it's a good addition to the bill. I mean, I remember when I was in local government, we made a big effort to try and stamp this out. Some of it's educational, but you can't do this. And I appreciate your raising it, and I hope that we can work together between now and the floor to make sure it's tightly drawn. And I thank the gentleman for yielding.
And I appreciate your point. I think we got everything that needed to be there, but I'm open to the possibility we missed something that needed to be fixed, and I yield to the chairman.
Let me say that first of all, I want to thank you for raising this. This is a good. Adding female genital mutilation to the bill is a good addition to the bill. I thank you for raising it. There are some problems with the way you've drafted it. I would ask that if you withdraw the amendment, we will work with you to craft an amendment to the bill by the time it goes to the Rules Committee that will accomplish this purpose. If you want, I can say what some of the problems with the amendment as drafted are, but it's not necessary. I'm sure we can work out an amendment that will do exactly what you want.
And I have your assurance that we will address this.
You do.
And the funds will be available for women that are victims of female genital mutilation.
Well, you have my assurances that we'll have an amendment to allow all this. Does your amendment appropriate funds? I didn't see that.
No, it doesn't. It just
It
allows
makes it eligible.
funds already.
Yes, we will
makes-
certainly, you have my assurance on that point. We will have an amendment which will make grant fund, which will make programs dealing with victims of female genital mutilation eligible for all these funds.
So I do want to know, is this amendment considered in order?
The amendment, yeah, as far as, yes, the amendment is in order,
Yeah.
but if
But
the
I
way
mean,
it's
we'll
worded, we would have to oppose it now. But if you withdraw it, we will do the same thing in a way that we will agree on drafting.
I just want to be sure, understand that to which we're agreeing. If the chairman is saying we're going to have an amendment and make sure there is an amendment and it's not part of the bill,
No.
then
We
we
will
agree.
endeavor.
Then
we will
Mr.
endeavor-
McGovern may not let it be part.
We will
somebody-
endeavor to make it part of the bill.
Okay, so it'd be part of the bill, and we wouldn't have to go fight at rules to try to get
It'll
it.
be part, we will endeavor to make it part of the substitute reported by the Rules Committee.
With that, I appreciate the chair, and I will withdraw the amendment.
Thank the gentleman. Are there any further?
Appreciate
And we
Chair's
will
effort.
work with your office on this.
Yeah, and I just wanted to, I thank the gentleman, the chairman for you, and I thank the gentleman for Texas, but we will, and I'll be going to the rules as well, so we will make sure that this happens.
And I just want to assure, we will work with the gentleman's office on this. And I again want to thank the gentleman for bringing up the subject. It is a very important one. Are there any further amendments? For what purpose the gentleman seek
Have an
recognition?
amendment at the desk,
Another amendment.
another amendment.
Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1585, offered by Mr. Gomert of Texas.
Without objection, the amendment is considered as read. Gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. This amendment to the amendment in the nature of substitute would remove the gender identity language from the bill and return Violence Against Women Act to its original purpose of protecting women and girls. As we've heard in the hearing on this bill, predators, and I know there are people that said they're not aware of such things happening. They are happening. There's numerous examples of problems that have arisen. But abused women and girls need their own space for their own safety and to recover from their trauma. There's plenty of psychological evidence about the damage that is done to women who are victims of abuse, sexual assault, domestic abuse. They are particularly vulnerable to post-traumatic stress disorder. And it's interesting, the more you read, the more you find that according to the evidence, the medical evidence, the psychological evidence, women are more likely, who are victims of sexual assault, are more likely to suffer post-traumatic stress disorder than are even soldiers. Because the thinking of the shrinks is that soldiers are trained for the violence, but there's no proper training for a woman who is going to be or is sexually assaulted. From health.com, the quote is from Dr. Ritchie, in some ways the trauma from sexual assault may be worse than the trauma from combat because normally soldiers are prepared and trained for combat. But there further data indicate 94% of sexual assault victims, female sexual assault victims, experience symptoms during the first 2 weeks after the incident, and up to 50% struggle long-term. For these survivors, day-to-day events can hit especially hard, and like any mental health issue, PTSD can be debilitating. Whether you're trying to support a sexual assault survivor or just seeking to understand the Me Too movement more clearly, there are other things that are important. PTSD is commonly associated with combat veterans. About 50% of PTSD cases are soldiers. But being sexually assaulted or abused is such an invasion of a woman's body, personal space, and safety that people can't move past that point. The brain does not perform well for a victim during a sexual assault, and this is because the fight or flight response kicks in. Unfortunately, victims are overpowered and they can do neither. That may instead dissociate themselves from the act, and that's where the mind escapes the body until the assault is over. Because dissociation is common among sexual assault survivors, during and after the event, a 2015 study showed and found strong links between dissociation and PTSD. We have not only the lawsuit that my friend from Arizona mentioned, but, and that was the women in a homeless shelter being suing because what occurred by having a biological man in the private area for women. And look, I understand the reason for the majority pushing for transgender. It's born out of a sense of wanting to help those who are suffering. And that's a very noble intention. But my friend, Mr. Cincillini, mentioned about the Equality Act, and I would humbly submit that it's actually going to do more harm. You're going to change sports into men's sports and co-ed sports. So anyway, we need to protect women. They are particularly vulnerable after a sexual abuse attack. For heaven's sake, give them some privacy where biological men will not come in and traumatize them yet again. And I appreciate the chair's.
Time of the gentleman has expired. I recognize myself for 5 minutes in opposition to the amendment. This amendment seeks to do two things. Number one, it removes all references to gender identity from the bill. Gender identity has been included in VAWA since the last reauthorization in 2013. Any legislation that seeks to deny protections to LGBTQ victims of the VAWA crimes would be a rollback and extremely detrimental to individual people and their communities because LGBTQ victims face discrimination in accessing protection and services, and this language in this amendment would roll back the 2013 amendments to the disadvantage of victims in those communities. The second thing it does is it strikes the ability of the Department of the Bureau of Prisons to consider on a case-by-case basis circumstances with certain circumstances with reference to their placement, including people's prison's own views with respect to their statement. Transgender people in prison are exposed to horrific rates of abuse by both staff and their fellow inmates, facing physical and sexual assault at much higher rates than their counterparts. The 2015 U.S. Transgender Survey found that transgender people in prison are 10 times more likely to be assaulted by their fellow inmates and 5 times more likely to be assaulted by staff. Transgender prisoners also face numerous other challenges behind bars, including denials of medical care. The Bipartisan National Prison Rape Elimination Commission, established by President George W. Bush, developed regulations for the Federal Bureau of Prisons that require case-by-case placement decisions, that only sex-appropriate correctional officers be authorized to conduct strip searches or enter bathrooms, and that prohibit searches to assess a person's genitals. This bill simply codifies already existing federal regulations, existing since the Bush administration, I believe, or since the National Prison Rape Elimination Commission's recommendations. He established it. The bill simply codifies already existing federal regulations that pertain to transgender inmates. The amendment would would prohibit such would undo the codification and that the bill would do, and would undo the existing regulations that have been in place for years. There is no good reason to roll back protections that have been afforded for many years to transgender federal inmates. For these two reasons, this amendment is aimed, or will have the effect of, I shouldn't say aimed, will have the effect of greatly reducing protections for federal inmates who are transgender, reducing the discretion of the Bureau of Prisons to be able to protect them properly. For those reasons, I urge everyone to oppose the amendment. Are there any further discussion of the amendment?
Mr. Chairman.
The gentleman from Georgia.
Thank you, Mr. Chairman. I move strike last word. I appreciate the conversation from both chairmen, but I also appreciate the gentleman from Texas bringing this. I think it's something that does need to be discussed. And I will support this amendment and yield to the gentleman from Texas.
Thank you. And I appreciate that. And I did note a very good concern that was being addressed in the bill by saying that, no custodial officer could do a strip search just for the sole purpose, as it says, of determining sex. So you can see that's dealing with an obvious problem. You could have people working in prisons that abuse that. And so the way that has been addressed in the amendment is you would only allow licensed medical doctors and a licensed RN, registered nurse, to make such checks. But we have a case from Toronto, was mentioned, where a guy claimed to be transgender, ended up being a dangerous offender, attacking women in the restroom. We have this case from the UK where supermarket toilet or restroom had a sexual assault of victims. But I want to go back to the point of how traumatizing it is. In my days on the bench, I heard the testimony over and over, but to have a man come into a confined space where a woman is who has been sexually assaulted, it puts her so often right back through that same trauma again. And this act is intended to help women. It might surprise some people here. I still, after 16 years off the bench, have women come up to me and thank me for being the only judge that did the right thing by the perpetrator of violence against women, because it was clear what was going on. My heart here really is for the women. I am sympathetic to the harassment and problems and even attacks that transgender have, but there is a solution besides further traumatizing women that this act really does want to help, but is going to condemn them to suffer continued PTSD because we are allowing biological men, whether claiming to be transgender, some may be, but it's also important to just look at the DSM-5. And so much of it's in there has been affected by politics as much as medicine. But when we talk about transgender, we're talking about gender dysphoria. Dysphoria, you know, is the opposite basically of euphoria. Gender dysphoria, what we call informally transgender, is distress that accompanies the incongruence between one's experienced and expressed gender and one's assigned or natal gender. And dysphoria then is defined a condition in which a person experiences intense feelings of depression, discontent, and in some cases indifference to the world around them. That's not a healthy situation. But the best is a 30-year study in an area, many areas of which transgender was totally accepted. Transgender or people suffering gender dysphoria were 20 times more likely to kill themselves. It is an alarming rate. Johns Hopkins, that did the first gender change surgery, after 20 years quit doing it because they could not find evidence they were improving the lives of the people that they removed functioning organs from. So they stopped. It has now been started back after they were threatened with cutoff of federal funds if they didn't start the process of cutting off the functioning organs again. But this gender dysphoria is an important issue, but for heaven's sake, let's deal with it in a way that we don't further traumatize women who have already been assaulted. And that's the reason I'm bringing this. I've just seen too many women traumatized too many times, and they need help. And as I pointed out before, though, at some point, my friends are going to look back and go, wow, we destroyed women's sports because now there's co-ed sports and there's men's sports. And it really needs further evaluation. I yield back.
Chairman,
The gentlelady from California.
I move to strike the last word, and I would yield to the chairman such time as he may consume.
I thank the gentlelady for yielding. I'll be very brief.
What do you think?
We should not, to deal with the possible case of of misconduct by one correction officer, amend the law to prohibit the Bureau of Prisons from properly dealing with transgender and other prisoners. And again, this language simply codifies regulations that have been working very well with, basically very well. I'm not aware of many complaints about it since the George Bush's National Prison Rape Elimination Commission. People of different genders need different protections and perhaps different placements. The Bureau of Prisons, under current regulations and by this bill under the law, would be able to give serious consideration to the prisoners' own views with respect to their safety and with respect to health and safety of the other prisoners at the facility. It's good language. We should not remove it. I therefore oppose the amendment. I yield back, and hopefully we can take the vote now.
Mr. Chairman,
Who seeks recognition?
I'd move to strike the last word.
Gentleman's recognized.
Yield to the gentleman from Texas.
Thank you. Another case from Decatur, Georgia, where a transgender bathroom policy, as the headline says, led to a kindergarten assault. A boy in elementary school claiming to be, and maybe he felt he was a girl, but he went in and sexually assaulted a girl in the restroom. I understand the intention, but for heaven's sake, let's don't use the Violence Against Women Act to allow further traumatizing or in this case in Georgia, from additional assaults on women. It is a sensitive issue, but talk to the women of sexual assault that have found themselves confined in a small area like a bathroom with a biological man. He can say he's transgender all he wants to, but it is traumatic to the woman, and I really hope that we can give these victims, these female victims of sexual assault, more consideration that's being given here. And with that, I yield back.
The question occurs on the amendment. All those in favor will signify by saying aye. Aye. Opposed, no?
No.
In the opinion of the chair, the noes have it.
Chairman, ask for a roll call vote.
Gentleman requests a roll call vote. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee?
No.
Ms. Jackson Lee votes no. Mr. Cohen? Mr. Cohen votes no. Mr. Johnson of Georgia?
Okay.
Mr. Deutsch? Ms. Bass? Ms. Bass votes no. Mr. Richmond? Mr. Richmond votes no. Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Stemmings? Ms. Stemmings votes no. Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia? Ms. Garcia votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Mr. Stanton? Mr. Stanton votes no. Ms. Dean? Ms. Dean votes no. Ms. Mucarsel-Powell?
No.
Ms. Mucarsel-Powell votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins? Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Jordan votes aye. Mr. Buck? Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Reschenthaler votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stubbe? Mr. Stubbe votes aye.
Are there any members who haven't? Mr. Neguse?
Mr. Neguse votes no.
Mr. Johnson of Georgia?
Mr. Johnson of Georgia votes no.
Mr. Liu?
Mr. Liu votes no.
Mr. Deutsch?
Mr. Deutsch votes no.
Are there any other members who wish to be recorded who haven't voted yet? The clerk will report.
Mr. Chairman, there are 11 ayes and 22 noes.
Then the amendment is not agreed to. Are there any other amendments?
Mr. Chair?
For what purpose is gentlelady seeking recognition?
Thank you, Mr. Chair. I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1585, offered by Ms. Lesko of Arizona and Mr. Shabbat of Ohio.
Without objection, the amendment will be considered as read. The gentlelady is recognized to explain her amendment.
Thank you, Mr. Chair and members. This amendment, I just want to reiterate that none of these amendments that I am offering or we are offering would prevent any organization, any shelter from taking in whoever they want. But what we want to prevent in my amendment is the government forcing a religious affiliated organization to take in people that is against their faith, meaning if they choose not to take in, let's say, biological males in a women's shelter, and they're a religious affiliated organization, that the government wouldn't be forcing them under this amendment to violate their
I reserve a point of order.
beliefs.
Lady reserves a point of order. The gentlelady will continue.
And thank you, Madam Mr. Chair, and I yield back my time.
Gentlelady yield. Would gentlelady yield?
I will yield time to Mr. Collins.
Thank you. And again, I just wanted to, before you, I appreciate the gentlelady bringing this amendment. I appreciate, again, all the hard work that has been performed on this in the attempt to clarify various things. And I do appreciate the gentlelady's amendment, and we'll be voting for it. And that, I'll yield back to the gentlelady.
Thank you, Mr. Collins, and I will yield to Mr. Shabbat.
Yeah, I'll move to strike the last word, Mr. Chairman.
Well, you don't have to move to strike last word. The gentlelady yielded to you.
I will,
She struck the last word. It's been struck.
Well, we may not get it all in here. I'm pleased to join the gentlelady from Arizona, Ms. Lesko, for offering this important amendment. I was moved by her sharing her story of domestic violence at our last hearing on this legislation, and I welcome the opportunity to join her in introducing this thoughtful amendment. Protecting women against violence is an issue that's not only important to me and many on this side, but it's an issue of great importance to many of my constituents back in Southwest Ohio, as I'm sure it is in districts all over the country. Just a few months before I was first elected to my seat in the House, Congress passed into law the first iteration of our legislation, this legislation, and since I've been in Congress, I've voted at least 10 times to continue to expand these important protections for women who have been subject to domestic violence, abuse, and harassment. That's both in this committee and on the floor, at least 10 times. Historically, this legislation had been bipartisan. In fact, in 2006, all but 4 members of Congress voted for its reauthorization. So what's happened between then and now? Well, it seems to me that some on the left have decided that they can use this critical legislation that's intended to protect women and girls from violence as a vehicle to promote a far-left agenda. To me, this is a disturbing development, as the safety and well-being of women and girls in this country is far too important to jeopardize with cynical political calculations that could further divide the American people. It's time to put politics and political agendas aside and reauthorize the Violence Against Women Act that provides protections for women and girls. And that's a goal on which I and many on this side sincerely hope that we can all agree on. I joined Ms. Lesko on this amendment because, as this legislation is currently drafted, faith-based organizations who provide services to women and girls who experience domestic violence, sexual assault, harassment, stalking, or other kinds of violence will no longer be able to do so in accordance with their faith. And that is a mistake that we can avoid, that we should avoid. Whether it be in instances of hiring or in implementing grants or contracts authorized by the Violence Against Women Act, these organizations should be protected from being forced to provide services that are inconsistent with their organization's teaching or the spirit or the intent of the law that I voted in favor of, and many of us have voted in favor of in the past. In fact, it's possible that passing this legislation offered by the majority in its current form could result in some faith-based institutions shutting their shelter doors that so many women and girls have relied on for help, support, and protection over the years. And that, to me, would be truly unconscionable. We must do all we can to protect the most vulnerable members of our society. And as a member of Congress, I've worked consistently to do just that, as many of us on this side have. To protect the religious freedom of the American people and to make sure that many important shelters remain open, I gladly join the gentlelady from Arizona, Ms. Lesko, in our amendment, and I would urge my colleagues, particularly those on the other side of the aisle, but certainly those on this side of the aisle, to support it as well. And with that, I yield back whatever remaining time there is to Ms. Lesko.
Thank the gentleman for yielding. I will yield myself 5 minutes in opposition to the amendment. What this amendment seeks to do is 2 things. Number one, it says that any religious entity described in the Civil Rights Act, and I don't have that definition in front of me, but not described in this bill, but any religious entity may not be subject to any prohibition of workplace discrimination on the basis of religion. Second, it says that a faith-based organization may adopt standards with respect to employee conduct and to delivery of services. In other words, they can say, we don't want to deliver services to gay people who are sexually abused, or to transgender people, or for that matter, to Protestant people. They can, based on their religious beliefs, they can decide not to deliver services to any class of people that they say violates their religious beliefs, providing services delivers that would violate their religious beliefs, and they can discriminate in hiring on the basis of religious beliefs. I'll make 3 points. One, the bill, regardless of any, I was busy trying to figure out what the amendment does, so I missed some of what Mr. Shabbat said. But regardless of any alleged left-wing agenda or far right-wing, left-wing plot or anything, the bill doesn't change anything in this respect. The bill doesn't deal with the subject. The amendment would seek to introduce a new idea into the bill, namely what we were just talking about. Insofar as there are problems, they exist in current law, and the bill would not change that in any way, number one. Number two, the law generally permits a religious entity to discriminate in employment on the basis of religion when you're dealing with people who have some role in promulgating the religious doctrine, the minister, the rabbi, the lay leader, but not when you're dealing with completely secular jobs. So that if federal funds are provided for a church-operated food dispensing, food pantry, the church can certainly discriminate on who the minister is, but they cannot discriminate on the basis of religion and who serves the food or who the janitor is. This would permit them to do that, and that is, frankly, wrong. It's against religious freedom, basically. This also would allow faith-based organizations to deny delivery of services based on their religious beliefs. If they have a religious belief that denies service to a segment of the population, they should not be taking federal money to do so. Federal money must be dispensed in a non-discriminatory manner. Religious organizations can have any belief they want, but if they want to use federal money to provide certain services, they've got to be able to provide those services to whoever meets the requirements set by law for the receipt of those services, and cannot be heard to say, we will not provide food in a food operation, in a food pantry, or we will not provide domestic violence services to people of a different religion or to people who our religion doesn't particularly hold in great respect, like gay people, period. If they want to do that, they're free to do it, but not with federal money. And that's the basic reason why this amendment is wholly unacceptable in its concept and its purpose. I would also add that the bill doesn't deal with this at all. It's misplaced in this bill, but even if it were placed properly in the bill, and I'm not going to raise a point of order, though that's debatable, but even if it's properly in the bill, it's wholly improper in its intent, because it would enshrine the right of any religious group to discriminate on any basis. We do not permit someone to operate, a religious group to operate a for-profit business or a non-profit business with federal funds and to discriminate on the basis of religious belief or on the basis of status. We won't. What if you had a religious group that says we don't like to serve black people? We don't think black people should get help with when they're victims of domestic violence. So so I completely urge all my colleagues to vote against this, and I yield the balance of my time to the gentleman from Maryland.
Thank you, Mr. Chairman. Just to elaborate on that point, is your reading akin to mine that under this amendment, a domestic violence provider would be able to refuse services to interracial couples, to interfaith couples, to same-sex couples, if there's a claim that it offends the moral convictions or religious ideas of the provider?
You're back. The question occurs on the amendment. All those in favor will signify by saying aye.
Aye.
Opposed, no. No. In the opinion of the chair, the noes have it. The amendment is not agreed to. A roll call vote is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass? Ms. Bass votes no. Mr. Richmond? Mr. Richmond votes no. Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Mr. Liu votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Stemmings? Ms. Stemmings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia? Mr. Neguse? Mr. Neguse votes no. Ms. McBath? Ms. McBath votes no. Mr. Stanton? Mr. Stanton votes no. Ms. Dean? Ms. Dean votes no. Ms. Mucarsel-Powell? Ms. Mucarsel-Powell votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins?
Aye.
Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Buck? Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Reschenthaler votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Armstrong votes aye. Mr. Stubbe? Mr. Stubbe votes aye.
Have all members voted? The gentlelady from Texas.
Ms. Garcia votes no.
Gentleman from Tennessee.
Mr. Cohen votes no.
Gentlelady from Texas.
Ms. Jackson Lee votes no.
The gentleman from Ohio.
Mr. Jordan votes aye.
Does anyone else, does any other member of the committee wish to be recorded who hasn't been recorded? The clerk will report the result. Yeah.
I understand your point, but everything, we're gonna do it on both. I understand.
Mr. Chairman, there are 12 ayes and 23 noes.
The amendment is not agreed to. The question now occurs on the amendment in the nature of a substitute. All those in favor respond by saying aye. Aye. Opposed, no. No. In the opinion of the chair, the ayes have it. The amendment in the nature of a substitute is agreed to. You want a roll call?
Roll call, yes.
A roll call is requested. The quorum being, a roll call is requested on the amendment in the nature of a substitute. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Aye. Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Deutsch?
Another vote after this.
Ms. Bass? Ms. Bass votes
Would
aye.
the clerk suspend from? Let me just make clear, this is a vote on the motion, on the amendment in the nature of a substitute. Immediately following this vote, assuming it's approved, we will vote on the bill. So this is the next to last vote. It is not the last vote, so please understand that on both sides of the aisle. Clerk will continue.
Mr. Richmond? Mr. Richmond votes aye. Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Ms. Stemmings? Ms. Stemmings votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon?
Have one more vote, right?
Ms. Scanlon votes aye.
That's it.
Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean? Ms. Dean votes aye. Ms. Mucarsel-Powell? Ms. Mucarsel-Powell votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Collins? No. Mr. Collins votes no. Mr. Sensenbrenner? I ate a salad. Mr. Shabbat? Mr. Gomert? Mr. Gomert votes aye. Mr. Gomert votes no. Mr. Jordan? Mr. Buck? Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stubbe? Mr. Stubbe votes no.
Ms. Jackson-Lee?
How am I recorded?
You are not recorded.
Let me record enthusiastically, aye.
Ms. Jackson-Lee votes aye.
Is anyone Mr. Correa?
Mr. Correa votes aye. He's already recorded.
Is there any other member of the committee who wishes to vote who hasn't been recorded? The clerk will report.
Mr. Chairman, there are 21 ayes and 10 noes.
The amendment in the nature of a substitute. Who? The amendment in the nature of a substitute is approved. Well, we'll reopen the vote. Ms. McBath. The amendment in the nature of a substitute.
Ms. McBath votes aye.
And the amendment in the nature of a substitute is still approved. We'll now, a reporting quorum being present, the question now is on the motion to report the bill H.R. 1585 as amended favorably to the House. Those in favor respond by saying aye. Those opposed, no.
Aye.
No. The ayes have it. A roll call is requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Deutsch? Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Richmond votes aye. Mr. Jeffries? Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Ms. Stemmings? Ms. Stemmings votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean? Ms. Dean votes aye. Ms. McCarcel-Powell? Ms. McCarcel-Powell votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Collins? No. Mr. Collins votes no. Mr. Sensenbrenner? Mr. Shabbat? Mr. Gomer? Mr. Jordan? Mr. Buck? Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stubbe? Mr. Stubbe votes no.
Has every member who wishes to be recorded been recorded? Mr. Gomer?
Mr. Gomer votes no.
Mr. Jordan?
Mr. Jordan votes no.
Has everyone been recorded who wishes to be recorded? The clerk will report.
Mr. Chairman, there are 22 ayes and 11 noes.
The ayes have it. The bill as amended is ordered reported favorably to the House. Members will have 2 days to submit views. The bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments. And without objection, staff is authorized to make technical and conforming changes. This concludes our business for today. Thanks to all of our remaining members for attending. The markup is adjourned.